We are so happy that you've decided to join us today. We are very excited to provide you with exclusive information and resources that will give you a deeper understanding of us and our services here. My name is Emily, and I'm the Marketing Director for Clinkscales Elder Law Practice. We're actually celebrating our 40th years of Clinkscales this year with our main office here in Hays and then our other office in Wichita, and we do serve clients and families throughout the entire state of Kansas. I would like to invite you all to type any questions that you may have in your chat box that's located at the bottom of the screen throughout the entire presentation. And then at the end of the workshop, we will address any of those questions or concerns that you may have. And so without any further ado, I would like to hand it over to our attorney and managing partner, Jenny Walters, to get us started.
All right, thank you, Emily. Well, today, as advertised, going to talk about some secrets to estate planning and protecting your family. I had to include this because I thought the invite that we sent was really funny, and considered I thought it would be funny to dress up like that or something. But going to try to make a sometimes dry topic a little more interesting. I've included some memes in the slideshows. I hope they're not too distracting. Maybe they're just entertaining for me, but just tried to, in the spirit of the invite, make it a little more fun. So this is for you if you don't have an estate plan or you have one that's out of date. You're not sure what your estate plan does or how it works or whether it will even work. You want to preserve and protect your property and income for your family, want to be sure your wishes are followed, and you're worried about the cost of long-term care. So if these ring true to anyone, then you are in the right place. If you could wave a magic wand, would you want to stay at home as you age, have a plan to make sure that you have someone to carry out your wishes, whether you're incapacitated or upon your passing? Have a plan you know how it will work and know what it says, understand how to pay for care if it comes to that point, and just have some peace of mind that you won't lose everything to long-term care costs and your goals will be protected and your wishes carried out. We'll get to the secrets and the information, but first, I want to talk a little bit about the office. We are an elder law firm, but I'm going to expand on that a little bit. I'd say mostly we deal with, if you want to say, quote, elder law issues, but that can expand into different things. As generally focus on helping families preserve and protect their dignity, their finances, their legacy. We practice throughout Kansas. We have an office here in Hays, which is where I'm at, and also an office in Wichita. It began in 1983 by Randy Clinkscales, which also happens to be the year I was born. So Randy's 40th anniversary of the office was also my 40th birthday, which was kind of fun. And we have a pretty unique and holistic approach that kind of all started with Randy's grandma, and I will get to the details on that. One of the things that makes us unique is that we have something called care coordinators. And we have 2 registered nurses and 1 social worker. They all have nursing home experience and they all have dementia training. It's Jessica, Jill, and Amy, and they help guide families on care needs and placement and home care and anything that goes along with any care issues, whether it's an elderly person or just somebody with a chronic illness or disabled. And we're just really unique as a law firm to have them, and I'll kind of explain why we have them. I don't want to forget about the rest of our support staff. They include 3 benefits specialists who mainly just work on Medicaid applications because they're extremely difficult to get through. And then we have legal assistants. Overall, we're up to about 20 people now. So I usually don't like to talk about myself, but I think it's important to understand, who you're hearing from. So I have been an elder law attorney since 2009, which is when I graduated from law school. So I've been here 14 years, and this is the only place I've ever been, which is I've been really fortunate in that way. And I focus on people with aging and even if not aging, just chronic care issues, helping them protect assets, qualify for Medicaid, and have effective estate planning. And really a lot of what I do here at the office is focusing on Medicaid planning and protecting assets. These are my kids, and we like our animals. We just got a puppy. So if anybody has any potty training, good vibes to send my way, I need them. And I'm married, but he's not as cute as the kids are. So I just included them. Boring stuff, but important. All of us attorneys are members of the National Academy of Elder Law Attorneys. There's a Kansas chapter with attorneys. We like to get together and talk about issues we're having with CanCare and all that. But I also wanted to point out we're a member of this Life Care Planning Law Firms Association. And that ties back to our uniqueness and having the care coordinators. Right now, we're the only law office in Kansas that is a member of this association, I believe. But there are other firms around the country that have some of the services that we have involving, planning both on the financial side of things and the estate planning, and then also having the care coordination to go along with it. So it's really special, and I'm glad to be a part of it. I mentioned that this all started with Randy's grandma, and I think it gets to a little more of the story. There's an example later, but he suddenly became the caregiver of his grandmother, and just trying to keep her independent and figure out the best care for her was overwhelming for him. And he started again a while ago practicing in this area of elder law, of chronic care issues, and we've just been focusing on that ever since. And what was important to him was having a plan and having a guide in that care coordinator, and just being along for the journey and having a plan for that. And so you'll see in our materials that we talk a lot about his grandma, because that's where it all began. Okay, let's get to the material. So we're going to start with number 1, how to keep the government from controlling your property, your decisions, and your affairs. Because if you don't have a plan, the government will provide one for you according to what the law says, and it may be up to the courts to make decisions for you, because no one has the automatic right to help you or to carry out your wishes, not your spouse, not your kids. Even in healthcare decisions, there is nothing in the law that says that somebody can automatically take care of things for you. And so you can determine who has that authority, but you have to have the right documents to get that done. And it's not just having some forms. It gets a little more detailed than that. So if you're incapacitated and you don't have a power of attorney, which we'll get to, you have nothing, then someone, a loved one, or if you have no one, it could be just an attorney, petitions the court to get a guardian and a conservator appointed for you, so you have someone that can legally make decisions for you. You have to pay for it with your own money. I mean, you're incapacitated, so they're using your money to pay the attorneys and all that. And it's a pain, it's extra steps, it's unnecessary in most situations, because you can prevent it with having powers of attorney. But for us, in addition to that, it puts restraint on some of the planning things we can do, because we feel like we have to go to court and get permission for some things, and maybe we won't get it. So we can work with it, but we really try to avoid that anytime we can. And then if you die without any documents, it goes back to what the law says as far as where your property goes. It could go to, if you have beneficiaries listed, but if you don't, what the law says is if you're married, half goes to your kid, half goes to your spouse. So your spouse could lose half the property by not having it set up correctly. If there's minor children, then a conservatorship may need to be set up, and even for a disabled person, and a guardianship to deal with their just their care needs. So it's not a good situation to be in. So to avoid this, there are some, we call them essential documents, that you really need to have That includes the financial power of attorney, healthcare power of attorney, living will, and then finally a will or a trust. And we'll get into more details on all of these and why they're so important. First of all, the financial power of attorney. To me, this is like the ticket that if somebody is losing capacity, if somebody has even physical disabilities that make it difficult for them to sign, for them to get out, like this is the ticket to have someone to take care of things for you. And what you do is you have the document where you name an agent to have legal authority to make decisions for you, to handle your affairs, to pay your bills, all of that. And then we usually like to have at least one backup just in case the first person you named, or maybe it's multiple people acting together. There's also the decision of, do you make it effective now? Are you giving those people the authority right now, or only if you become incapacitated? And that's a decision that we talk with people about. You can also name in that document that if you ever have to have a guardian or conservator, maybe it's just because you're making poor decisions and somebody has to take over, you can name who you want appointed as that person. But the thing with powers of attorney, and it's common for people to think, well, I have a power of attorney, I'm fine, everything's taken care of. But the power of attorney is only as good as the actual powers it contains. There are some specific powers in Kansas law that if they're not in that document, your agent can't do them. And so for us, especially with Medicaid planning, if we want to transfer the home, if we want to give assets away, if we want to set up a trust, if we want to change beneficiaries, if that authority is not in the power of attorney document, we're stuck. And so 99% of the time we try to get our power of attorney in place because we know it has every single thing we could possibly need to do for somebody. Again, it's that ticket to anything that needs done. Next are the healthcare documents, sometimes known as healthcare directives. And I know that the writing might be a little blurry, but I thought this was really funny when I was looking for things to add. This last night, my sister and I were sitting in the den and I said to her, I never want to live in a vegetative state, dependent on some machine and fluids from a bottle to keep me alive. That would be no quality of life at all. If that ever happens, just pull the plug. She got up, unplugged the computer, and threw out my wine. So I laughed. That was funny. But in all seriousness, for healthcare decisions, like I mentioned earlier, for some reason, Kansas law does not have like a designated, it's not like your spouse or your kids have legal authority to make decisions. I think in reality, facilities and hospitals do listen to those people, but to make it official, you need a healthcare power of attorney to name the person you want to make those decisions, and again, a backup. And then something that goes hand in hand with that is your declaration, also known as a living will, that deals with your instructions for end of life. For example, our living will says something like, if two physicians say that I have a terminal condition that I'm going to die from, I don't want anything that's going to artificially prolong my dying process, like respirator, ventilator, tube feeding, antibiotics. Things can be tried for a short period of time, but if they don't work, I want them withdrawn and basically just want to be made comfortable. Another document, if it's appropriate, is a do not resuscitate, also known as a DNR. That's a conversation with you and your doctor. That's not a document we do. It's with your healthcare provider, if that's appropriate, if that's something you want for you. And finally, having a HIPAA authorization so people can just get information about you. Let's say you have your spouse as your healthcare power of attorney, but you want the doctors to be able to talk to your kids, so you can have them listed on that HIPAA authorization. I want to give an example to I think it helps tie all these themes together. Okay, what happens in real life? What does this look like? So let's say this is Mr. and Mrs. Wright. They went to a workshop. They have no estate plan. They got a farm and things are owned. Some of it's joint, just typical. All the assets are owned, differently. They went home to think about it. And sometimes this is a worst case scenario thing, but every once in a while, something crazy like this happens where there's no documents in place. In this case, he had a stroke, he lost capacity. She didn't have a power of attorney to get things set up correctly. And so like we talked about, things kind of revert to what the law says. Well, if property's joint, it goes to the joint owner, but the other property that wasn't held jointly went one half to the spouse, one half to the kids. And then, let's say that's farm ground, then the kids have to figure out if are they giving it back, and all of that. So we got all that cleaned up, and we'll talk about the types of trust. We set up an irrevocable trust to protect it. We got her powers of attorney, and just got everything set up correctly for her. And it ended up, got her protected from, a potential recovery from a lawsuit. And what she said was, should have done something when we came in. It cost us over $40,000 and created a lot of stress, which are equally difficult. All right, number 2. And again, I know Emily mentioned this. If there's any questions, feel free as you're going, put them in the chat. There's no dumb questions. And then if there are any, we'll get to them at the end. So I'm going to take this one step further. It's one thing to have the proper documents. You got your agent's named, you got a will or a trust, but we need to go a little further to make sure it actually works and that it's effective, and that it's unique to you and takes into consideration taxes, and your trustee knows exactly what to do and your wishes. And then finally, you've got to set up your assets correctly or the whole thing won't work. As I mentioned, it's more than just the forms. And here's some examples of how we get more detailed in this to make it work for your unique situation. So for example, most people have something we call sweetheart wills, where they're leaving the assets just outright to their surviving spouse. If I die, I'm leaving everything to my husband, or vice versa. But sometimes there comes to a point where that's not the best idea, because what if somebody needs long-term care? We don't want to dump everything back in that person's name. So in our documents, we set up a contingency plan that if a surviving spouse is disabled in long-term care on benefits, we're not dumping everything back in their name. We're giving them the minimum the law requires, which is about half, but the other half we can protect and not spend on care and not have it accessible to Medicaid or have to be spent down. There are situations where we want we have a disabled beneficiary, somebody on SSDI or somebody that could be on Medicaid, that we want to make sure their inheritance doesn't mess up their benefits. So we protect it in a trust for them. You can even specify, okay, I don't want my kids, our default's usually 25, or maybe you have a special situation where you don't want them to be able to sell farm ground, or you don't want them to get their assets until they're a certain benchmark. If there's farm ground, we can put in options to purchase, where if you have more than one kid, so they don't, the ground doesn't just get sold out from under everybody, that family members have the first shot at it. Think about passing on a business. Sometimes people want to provide for their kids as well as their grandkids. And then a big one that I've highlighted is being more proactive and planning against potential costs of long-term care by setting up an irrevocable trust. We'll talk a little bit more. Medicaid has a 5-year look-back period on gifting, and so sometimes we plan ahead and make some transfers, some gifts for Medicaid purposes by setting up that irrevocable trust, but preserve the step-up in tax basis and just make sure assets are protected for family and in a safe place for someone's lifetime. And again, I can't say this enough, make sure it's correctly funded. If we have a trust, make sure the real estate's actually deeded into the trust and that beneficiaries are changed correctly and bank accounts are changed. Like that, it does no good if the actual assets are not set up correctly. Then you end up in probate anyway. Here is a example. Again, just to kind of see how this plays out in real life. You've got Mr. and Mrs. Jackson. They've got, they've got their home, they got a business, some investments, retirement, no estate plan. And then you get into the situation with these kids. You got one kid that works in the business. You got one kid that is deceased, I had a typo there, and has a special needs child. You got one that's going through divorce or drug problems. All these things can go on with kids. And then the parents want the business to stay in the family. They want to be fair. They don't want people to fight. They do nothing. You got no powers of attorney. You got nobody that can act for them. You got a potential for probate. Then all the kids get everything equally. and now they all have to work together. Could lose the business. You got the daughter with the drug problem. You're dumping things in the lap of the kid with the grandkid with special needs, and it's a mess. So the solution to this would be to have powers of attorney with all those powers added, to have the healthcare power of attorneys, and then set up a revocable trust so that we have a place for all the assets to go and express why the business, how the business should be handled. So everything doesn't get divvied up to all these kids. The trust makes sure that the trustee can pay expenses and take care of things, and then everybody gets their inheritance according to what the trust says, and it's all much cleaner and stays out of court. I think one more example, Mr. and Mrs. Augustine, they wanted to transition the farm to their kids. They considered selling it, but that we explained to them was going to incur a lot of tax problems, which if they really just wanted to protect it and pass it on to their kids, the solution was to set up an irrevocable trust. There's some special tax language in that trust to where when their kids inherit it, they do receive that step up in basis, and we avoided the other problems that selling the real estate would have. So it worked out really well for them, and that's a pretty common scenario, being out here with lots of farm ground. So what do you need to do about this? And we'll talk about the strategy sessions, but get that scheduled, get a plan in place to accomplish your goals, and again, fund the plan and make sure everything is set up correctly. Number 3, paying for care. Nobody wants to move to long-term care. I mean, all of this is kind of worst case scenario stuff. Nobody wants to think about death or planning for that. Maybe a small percentage do, but especially not thinking about moving to long-term care. But you got to plan for it, because as we'll get to, it is so expensive that if you don't plan for it, I mean, it can go really quickly. And you can make the decision about how you pay for that. And most importantly, that I want everybody to know is you don't have to go broke if you need long-term care. This is a place where the law actually helps to protect assets. And that's what a lot of what I do is using what is in the rules and the law to help people protect assets. And if appropriate, we look at benefits to pay for care. Sometimes Medicare will pay for a short time, and then especially VA and Medicaid. Okay, so these are some numbers. Some of you may understand this from personal experience. This is kind of the range of what I'm hearing long-term care costs. In Hays, there's one facility I know that's up to $7,500 or more. I had somebody in, I think it was the south part of the state, say that their wife's care was going to be $9,000, and one of our care coordinators in Wichita said it could be 10 to 12. So it's so expensive and can deplete assets so quickly. It's scary. So a lot of what I do is looking for planning opportunities for people. Do we have long-term care insurance? Some people do, some don't, a lot don't. The VA can help pay for like assisted living or home care in circumstances. The VA usually doesn't pay enough for long-term care, but it can be really helpful in those other situations. We look at Medicaid, and we also look at private pay. Some people don't want to go on Medicaid. Some people have lots of assets, and Medicaid planning isn't appropriate. So it's not like we push everybody to Medicaid, but in the right circumstances, it can really be a lifesaver to protect assets. Sometimes we look, if we have a proactive, if we feel like we have 5 years before Medicaid, we set some assets, gift some assets to shelter them, to protect them, so they're not in the picture when that person does need Medicaid. If we have one spouse in care and we call them the well spouse still at home, there are some really good protections for that spouse so that they're not spending all of their money on care. We can shift money to the spouse at home and really protect a lot of assets for them. If we have a single person, there's a gift strategy we use where we intentionally give some assets away. It's usually about 50 to 60%. And while we do have to spend the other 40 to 50, we're still saving a good chunk of money for that person. Because when you're on Medicaid, they give you a whopping $62 a month for yourself. Maybe covers a haircut. So if we can shelter some money, that makes sure that that person can get some new clothes. Maybe they want an iPad. Maybe they want to pay for a cell phone. Maybe they want to pay for a private room. There's some extra money available to do that. And a big one is we look for, and we talked about Medicaid has the rule on gifting and the 5 years, but sometimes there's exceptions to that. If we have a disabled child or a child that's been a caregiver in the home for 2 years, like I can go on. And it's so important that if long-term care is in the is in the future, to talk with somebody about what the options are, because there are a lot of options and a lot of rules to apply there. And there's a lot of protections that people should know about. So in real life, we've got the Lundgrens. Mr. Lundgren, early dementia, but was still active in his farm, but understandably concerned about what was going to happen in the future. We got those strong powers of attorney in place, and this was that proactive 5-year plan where we looked at an irrevocable trust, made sure the care instructions were there while he had the ability to do that. And then we know that we hope he can stay, home as long as possible. But as long as we have those 5 years, he can feel, and his wife can feel comfortable that they're protected. Here's an example of something I call a crisis Medicaid planning, meaning we don't have the 5 years. We're planning for Medicaid now. So we've got Mrs. Smith has dementia. She's going from to the nursing home from the hospital, which is common. $8,000 a month for nursing home care is normal. And they've got some assets there that could be depleted. The nursing home told them they would need to spend all the assets before Medicaid would help. And it is so common for people to just hear little bits of information about Medicaid, how they're going to take things, how they're going to take your home, how you have to spend everything. And it's so important to talk to somebody that is an expert in the field and actually knows, because there's so many misconceptions out there. So it's so normal for people to have the wrong information. But our solution was to use the Medicaid rules to shelter assets, to shift the assets to Mr. Smith and qualify her for Medicaid in a way that we didn't spend all the money down, because it's important that our well spouse be able to stay at home and have enough money to live on. And then it goes back to those care coordinators, that while we were able to protect them financially, we also had someone helping Mr. Smith make sure his wife gets good care, because that's really the most important thing, is for somebody just to get good care. And then an added, this is where the VA benefits comes in, that sometimes they're appropriate to give somebody some extra money. Again, it really works well in assisted living because the costs aren't quite as high, and that can help stretch. When you combine that with somebody's income with the VA, it helps stretch their assets a lot longer to allow them to stay there longer. What do you need to do? Schedule that strategy session to talk about those Medicaid rules and the options. Explore all the funding resources. Is it private pay? Is it Medicaid? Is it VA? Is it long-term care insurance? Obviously have those powers of attorney in place just in case you can't make the decisions for yourself. And the goal is always to find, get, and pay for good care without going broke. Number 4, how to stay at home. And most everybody wants to stay at home. And I think it's important for people to know it's not a ticket from home to the nursing home. There is staying at home. There's getting home health care. There's independent living, assisted living. There's these things called home pluses, and then to long-term care. And this goes back to Grandy's grandma, and a little more details on that. She was 86. Her daughter, who was her caregiver, Randy's mom, died unexpectedly. And so then there's Randy living 500 miles away, and having to help her with their health issues. She was frail, she was depressed, and she didn't have a lot of resources, and she wanted to stay independent. But how was he going to do that? So he ended up finding some resources in the community. She was able to stay home for a while. He moved her to assisted living in Hayes, actually, and she was able to stay there, and did need some advocacy from the care coordinator to, because that's where she wanted to be. She didn't want to go to long-term care. She wanted to stay in that assisted living as long as possible. She went on hospice a few times, came off, and ultimately only spent 50 days in long-term care and died at 96. And so he's just passionate about that, having that guidance. He was able to have a gradual transition for her, and really enjoy being her grandson, and having that extra person as the care coordinator to help him through it. And just wanted to share this note from Sherry. Her husband had Parkinson's, and she said, "You helped me keep him in his home as long as possible, which is always our goal, and showed me how to be a better caregiver. I could not have figured out how to pay for care with Medicare and Medicaid on my own." Again, it goes back to, we have care coordinators that are trained in dementia, how to interact with them, how to communicate, and then the financial support and navigating all that. Wanted to share this from Pat. My husband needed nursing home care. You guided me through the process. Your care coordinators made sure my husband was getting good care. I highly recommend you because you're always there for your clients and will guide them through everything that goes on, things we never expected to go through, which is a really good snapshot of what our philosophy is to help navigate through everything. What do you need to do? If you or a loved one is facing aging or any chronic illness, it doesn't have to be elder law. It can be early onset dementia. It can be some other chronic illness that means you need more care or more support. Have that strategy session with us. And the longer you wait, the more the options can be limited. There are always solutions, but it's much better to meet with somebody earlier before they are in a crisis. But I'm always happy to meet with people in crisis to figure that out too. So far you've discovered there are documents that empower others to act for you, protect your wishes, and keep the government out of it. And having an effective estate plan is more than just the forms. It's really what the documents contain and how they apply to your situation. With planning, you can pay for care without losing everything, without putting the financial burden on your children or their family members. And really the takeaways, there are options. And there are ways to stay with home with the guidance of an expert. So how do you make that happen? Again, going to repeat myself, just a short call with us. It's painless. We get some general information from you, and then we schedule that a meeting. It could be a call or a Zoom with me or one of our other attorneys to get into more detail. And we'll discuss your financial and legal needs. We'll review your current estate plan if you have one, see if it fits your goals, talk about what your goals are, and really just answer what questions you have about your situation. Hopefully this conversation prompted some questions about your own situation. We'll analyze your plan. You'll have clarity of your issues and your goals, a blueprint of how to achieve them, and importantly, the exact amount of the investment to achieve them. After the meeting, when you decide to get started, we draft the summary of your plan. We prepare the documents that are the framework of the plan, the powers of attorney, maybe the trust or irrevocable trust, the will, the HIPAA authorization, the living will, and then we have you sign them. And then we have to do that. We call it funding. Again, almost the most important part is making sure everything is set up correctly, and we help make sure that happens. And if you are dealing with chronic illness or an aging issue, then we may get the care coordinator involved. So the value of that consultation is $650. But if you book your strategy session, it is free. We're waiving that. No, it sounds too good to be true. There must be a catch. But we do have limited spots in the next couple weeks. So to book that, you can call the number, or we're going to send you an email with a link for a survey. And that's another way you can raise your hand. And I'll guarantee that after speaking with one of us, you'll know more than you did today. Hopefully today you know more than you did yesterday, but you'll know even more after talking to us because we'll get into specifics on your situation. You'll have an analysis and what happens if you do nothing, and realize there's options, and that we can help guide and protect you and your family, and you won't waste your time. I guarantee it. So to book that session, again, you'll call or click on the SurveyMonkey. This is an example of what that email is going to look like and how you click on that link to take that survey. And as an added bonus, if you go through that SurveyMonkey, then you can get a book that Randy is an author in, and it's called What You Really Need to Know for the Second Half of Life, and also a written summary of our recommendations. So finally, again, call the number or click on the survey for a follow-up. And if anybody has any questions, I do actually love questions. So I don't know, Emily, if you have anything.
Yes, we do have two great questions so far.
Okay.
Jenny, how will an irrevocable trust work when estate is cash, investments, and IRA accounts?
We can pretty much transfer anything but IRAs to an irrevocable trust. We can protect farm ground. We can protect investments. You're not having to, basically it's an ownership change on the investments, but tax consequences are not triggered. Cash, same, it can be cash in the bank account or a CD. The tricky one is the IRAs because it's taxable money. You can't just change ownership of it because you're going to pay income taxes on your whole IRA. And so that's a tricky one. Usually we leave those alone unless there's a really good reason to cash them out and shift it over. And it's maybe that when we look at it as a whole, the IRAs are what you keep to live on, to take care of yourself, and that gives you the opportunity to protect something else. Good question.
Okay, great. Here's another one. Is there a way to protect assets even after my dad has entered the nursing home?
Yes, and that's really important. If he is married and we have a spouse to shift assets to, we can do that. If somebody is single, there's sometimes that gift strategy we can use, or spend down on things he really needs to make sure he's taken care of. But the short answer is yes. Just because somebody's in long-term care doesn't mean that the options are over and it's all going to be spent. You know, I definitely want to take a look at it.
Perfect. Thank you for addressing those two questions. It doesn't look like we have any additional ones in the chat box at this moment. But to everyone here, please feel free to add your question now as we wrap up our presentation for this afternoon. I just want to be sure and invite you all to another webinar that Randy, our CEO and president, is hosting on December 5th about how to pay for long-term care. So this is always our most popular and requested workshop. So if you'd like to receive information about that, you can visit our website at clinkscaleslaw.com or email me to get signed up, and you should all have my email address. And I would just like to kindly remind everyone that you will receive that important email that Jenny mentioned that contains the important items. It will include a recording of this session, and we like to provide that so you can share this with other family members, friends, colleagues, or anyone that wasn't able to make the session today, or just so that way you can go through and take notes on all of the important things that Jenny covered today. And then that SurveyMonkey link, I did also put it in the chat box. You can go ahead and try to redeem your free strategy session as soon as possible for you to complete. And I just want to reiterate that you can call our office at that phone number on the screen, the 877 number, if you have any questions regarding that strategy session, how the process works, who needs to be in that meeting with you, or if you just have any other questions, we're always happy to chat with you. I don't see any more questions in the chat box at this time. If you think of any, again, please feel free to call us. Make sure that you fill out that SurveyMonkey. And thank you all for joining us this afternoon. And thank you, Jenny, for sharing that really pertinent information with all of us today.
Thanks, everybody.